in Bingham County, case CR 2023-5201, State of Idaho versus Eric Whitney Jones. Mr. Jones is present along with counsel, Mr. Al Browning. State of Idaho is present, represented by Mr. Ryan Jolly. We're here today for a scheduled sentencing. Parties ready to proceed in this matter, Mr. Browning?
Yes, Your Honor.
State ready, Mr. Jolly?
Yes, Your Honor.
Mr. Jones, let me review the history of this case. At the time of your arraignment on October 10, 2023, your informative information had been filed against you by the state of Idaho, charging you with the crime of battery with the intent to commit a serious felony. At that time, you pled not guilty. However, on January 18, 2024, you again appeared in court and were found guilty at a jury trial that occurred on that day. After you were found guilty by a jury of your peers, ordered a pre-sentence investigation report along with the psychosexual evaluation. I have received those reports, both the pre-sentence investigation report and the psychosexual evaluation. Those also should have been provided to your attorney. So let me first ask Mr. Jones if you had a chance to review that pre-sentence investigation report. Mr. Brown, are there any parts of that report that need to be clarified or corrected?
On the pre-sentence investigation report?
Yes.
Just the first page, the allegation was concerning daughter AJ, but not EJ.
Okay.
That's in the first paragraph. That's all.
Give me 1 second. I'll have to open up another program to make that modification, but I will do so. Madam Clerk's going to strike the initials on the document. For some reason, my program. Any other corrections to that, other than that, Mr. Browning?
No, Your Honor.
All right. Is there going to be any witnesses or any witnesses on behalf of the defendant? Let me indicate the court's read through the various letters that were submitted, but certainly you're welcome to do more if you wish.
No, we'll roll on the statement, Your Honor.
All right, as indicated, I had read through those. Is there any witnesses or victim impact statement on behalf of the state, Mr. Jolly?
No, Your Honor, but I do have a PSI correction that I believe needs to be made consistent with Mr. Browning's request. On page 2, it lists both of his daughters as victims, and that under victim impact statement, it indicates the victims of the instance offense are Mr. Jones's daughters AJ, age 5, and EJ, age 13. The EJ, age 13 should be struck. She's not a victim of this offense. Along with that, also page 3 has a victim impact statement from her as well. That should also be struck. She was not listed as a victim for this offense.
I think instead of considering page 3 part of the pre-sentence investigation report from, or a victim statement, just a letter of support from family, I think we can consider it that way, Your Honor.
All right, the court will order the initials struck on page 2, consistent with what the court's already decided. The court is not going to strike the letter from Lauria Jones, but will accept it not as a victim impact statement but a letter of support for Mr. Jones. Anything else, Mr. Jolly?
No, Your Honor.
All right, Mr. Browning, before I announce sentence in this matter, will let you speak on your client's behalf.
Yes, Your Honor. Your Honor, Mr. Jones is terribly embarrassed about what he's done. He's remorseful about what he's done. As indicated, I think, in everything that the court has been provided, this is Mr. Jones has, I would call it temptations, urges, whatever you want to call it, that have troubled him for many years, and he's been in counseling with that for many years as well. This particular incident came up. He went immediately to his wife, to his bishop, to seek counseling. He's been in counseling for four years, believe it on this, Your Honor. Continues to be in counseling. This is just something that he has addressed. He and his family support system have worked just to make sure that the children are safe in this instance. I think the letter that Mr. Jolly references indicates that the defendant, in fact, with all this counseling, with the support system that he's got, at home and at the community, that he's actually been a very beneficial presence to his children. His whole family is very tight. They love each other. The family wishes to have him back, as a part of his life. They don't feel the need to be protected from him, other than, I'd say the safety plan that's in place, at this point. I think this is recognized by in the pre-sentence investigation report that the crime itself is upsetting. The pre-sentence investigator recognized that in this particular instance, Mr. Jones and his family have been addressing this for many years, and have addressed it in a positive way. For counseling with safety rules, around the house, and I think that's appropriate. I would ask for probation in this case. The family has asked for the removal of the no contact order. That's been extremely hard on the children. If we have a case, I dealt with all kinds of cases of abuse, alleged abuse, no contact orders, and like that. And the normal default for a court in all these cases is to immediately issue a no contact order. This is kind of a protocol that's always when there are allegations like this. In this particular instance, it's actually been harmful to the children. The children, we wish to protect the children. We wish the defendant to acknowledge the seriousness of the offense, have the appropriate punishment and appropriate rehabilitation, in place. And I think the no contact order has actually been a negative in this case. It could be a positive in the sense that it does help Mr. Jones and his family to recognize the seriousness, of the situation, and for Mr. Jones to redouble his efforts, in therapy, as he continues, as he wishes the court to know that if the court would be so kind, I would say, is to grant him probation, he'd throw himself into whatever rehab programs the court would recommend. He very much desires to be a father to his children, a husband to his wife, positive influence in the community. And people have known and considered him such, that this, unfortunately, is just, this particular crime is something that, he's here to answer for. And I think that, he's addressed it in the proper way. And I would just suggest, I believe that a particular sentence with probation up front, an underlying fixed and determinate portion, would be appropriate in this instance. All I can say is all the family members that are involved in here, would support that 100%. And they would hope that the court would see that would be a just result, a proper result for the family in this case. So I offer that to you, Your Honor. Thank you.
Thank you, Mr. Brown. Appreciate that. Mr. Jolly, can I have the state's recommendation?
Yes, Your Honor. So I want to start by pushing back on what was just represented to the court. The defense just represented to the court that the defendant has addressed this in the proper way. All of his actions since he engaged in this conduct indicate that he has not addressed it in the proper way. In fact, since he victimized his very first victim, he has not addressed this in the proper way. Now, as the court's considering whether it should place the defendant on probation or impose a sentence, it's going to look at the factors under Idaho Code Section 1925-21. And I want to go through each of these factors here today because I think it's important as I make my argument as to what, and it will be important for the court to understand why probation is not appropriate in this case. The number one factor under 1925-21 is the protection of society, followed by rehabilitation, deterrence to the defendant, deterrence to society, and then punishment. Under Section 2 of 1925-21, it lays out the factors that the court should give weight in favor of avoiding imprisonment, which is what the defense has asked for today with probation. First factor under subsection A, the defendant's criminal conduct neither caused nor threatened harm. This factor is not met in favor of the defendant. He committed a battery of his 18-month-old child with the intent to commit lewd conduct by pulling out his penis while he was aroused and placing it on his child with the intent of committing the more serious crime of lewd conduct. The threat for serious harm is substantial, and this very easily could have been a situation where he was charged with a more serious crime if, according to his own recitation of the facts, he had not stopped. So factor A is not met in favor of the defendant. Factor B, the defendant did not contemplate that his criminal conduct would cause or threaten harm. This factor is also not met in favor of the defendant. The defendant knew that what he was doing was wrong, and he knew that because he had engaged in this behavior not once with the current crime that the court's here to sentence the defendant on and what he was convicted on at trial. But the defendant acknowledged and admitted in the psychosexual evaluation that there's been 2 other victims of his conduct. He knew what he was doing was wrong and did understand that his criminal conduct would cause or threaten harm. During this cross-examination, I specifically asked him, what possible purpose could you have for pulling out your penis while you were holding your daughter, your 18-month-old daughter? He was speechless. He couldn't give an answer. And that's because he knew what he was doing was wrong, and there's only one explanation for why he did that. It's because he intended to cause even more harm to that child because he intended to commit the crime of lewd conduct. And that's what he's been found guilty of. So that factor is not met in his favor. Number C, the defendant's criminogenic needs indicate that the defendant will benefit from supervision and treatment in the community. And this is the factor where I think the court needs to rely on what's contained in the psychosexual evaluation. As I review that evaluation, there are factors that weigh both in his favor as well as against him. Some of the factors identified by Dr. Hatzenbuehler, which are protective factors, indicate his age. He's 43 years old. But I would also note that that cuts against him because he's been engaged in this type of behavior over a number of years. As I've already indicated, there have been 3 victims. I would add for the court that at his age, it seems highly likely to me that this is something that he's just going to grow out of, or that he's going to all of a sudden decide isn't what he wants to do. In fact, he acknowledges that he's been in treatment for a number of years. He's struggled with this his life. I believe he will struggle his entire life with this. But that is one of his protective factors, is his age. Dr. Hatzenbuehler also lists his disclosure as a protective factor. But I would add, yes, he disclosed, but he did not even disclose the same information to both his wife, his bishop, and his counselor. His disclosures between each of the 3 have contained different information. The general story that he provides is that he had impure thoughts, pulled down his pants, and then he stopped himself. But the court heard his bishop testify, Bishop Cooper. The defendant admitted to him he placed his penis on that child. When his wife testified, his wife indicated a story that was completely different than what she had initially told law enforcement. She said that she didn't believe he had ever touched the child, but she did acknowledge that he had told him told her that he had pulled down his pants and had impure thoughts when he had the child. So again, the disclosure I view as weighing both in favor as well as against. Yes, he's disclosed, but his disclosure has not been a full and complete disclosure in any of those instances. Another protective factor is no prior criminal activity. No prior criminal activity, based on what I can glean from the report, indicates no prior criminal convictions. But we already know that there's been at least 2 prior instances of criminal activity that the defendant's engaged in, which are the same nature as what he's been convicted of and what he's here to be sentenced on today. One was a child in China when he was teaching over in China. The other was his older daughter when he did the exact same thing, to his own admission, to what he was convicted of doing with his younger daughter. Finally, they also list as protective factors family support. There's no question that his wife supports him and that his children also appear to support him. But I would also add that also is a pro and a con for him. His wife was aware that he had initially abused his older daughter. She did not take it upon herself to report that to law enforcement. And subsequently, he was enabled by her lack of reporting to abuse another child. Now, it's not her fault that occurred, but she should have reported that. And as a protective factor, I view that as weighing against her. She's already shown she will protect him over the well-being of the children. Lastly, it lists stable employment, pro-social activities, and no substance abuse, and I would agree, those do weigh in his favor. One other thing that I would like to note for the court is that in the psychosexual evaluation, the defendant did not complete a full disclosure sexual history polygraph. And that's indicated on page 5. Now, I don't know all of the reasons why he did not complete that, but certainly concerning to me that the court here today does not have a full disclosure sexual history polygraph as part of that psychosexual evaluation to ensure that we're only talking about the victims that we're talking about. There isn't other conduct that we haven't caught, that there isn't other conduct that he hasn't disclosed. We don't know that because he did not complete that polygraph. Factor D, under the code section, there were substantial grounds tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. There's absolutely zero justification for the defendant's behavior in this case. There's never any circumstance where an adult, let alone the defendant, who was the father of this victim, should have had his penis anywhere near his 18-month-old child. Factor E, the victim of the defendant's criminal conduct induced or facilitated the commission of the crime. The victim in this case was 18 months old. She bears no responsibility for anything that occurred. She could not have induced him to do anything. She was an infant. She was a child. So that factor is also not met in favor of the defendant. Factor F, the defendant has compensated or will compensate the victim of his criminal conduct for the damage or injury that was sustained. I view that as inapplicable in this case. That's dealing more with a property offense or some other crime where financial compensation can be given for recompense for a crime. So I don't view Factor F as being applicable in this case. Factor G, the defendant has no history of prior delinquency or criminal activity or has led a law-abiding life for a substantial period of time before the commission of the present crime. I would note again for the court that the operative words here are prior delinquency or criminal activity. It does not say convictions. And the reason it doesn't say convictions is because we know, and this court is well aware, that there is often crimes individuals commit they're never held accountable for. And that's exactly what we're dealing with in this case. We know he's engaged in this behavior 3 separate times, 3 separate victims, over a matter of years. This was not an isolated incident. This was not a one-off situation. This wasn't something that just happened one time. He felt bad, acknowledged what he did, and it never happened again. That's not what we're dealing with here. This was repeated instances of conduct, multiple years, multiple victims. Yes, he has only been convicted of 1 crime today, but the court needs to consider that factor under G about his prior delinquency. Factor H, the defendant's criminal conduct was a result of circumstances unlikely to recur. For this factor, the court can also go back into the psychosexual evaluation to the risk classification portion. Risk classification, and this is important, is a defendant's assessed risk to reoffend when compared to other sexual offenders, not to the general public at whole. That's an important distinction because it acknowledges that sex offenders are in a category of their own. Those individuals, by their own nature, are more likely to offend again. The defendant's overall risk, according to the psychosexual, is a moderate risk. His primary risk is to young females to whom he has access. The psychosexual claims that he's not predatory, but more of an opportunistic sex offender. At the same time, though, he does have 3 victims. And that shows, that, as I've already argued, that this is not just a one-off instance of conduct. The psychosexual on page 4 also indicates that he should not be allowed to be in the presence of young female children without supervision. This defendant has 6 young children in his home, 2 of which he has already victimized. And one question I would have, and I think is a rhetorical question for the court, is how would the defendant be able to be on probation at home with his young children and be supervised and not in the presence of young female children without supervision? Because that's exactly the same circumstances he was in when he abused this child. Factor I, the character and attitudes of the defendant indicate that the commission of another crime is unlikely. Again, the defendant is a moderate risk to reoffend. And again, this is the 3rd time that he's engaged in this behavior. The character and likelihood of the defendant are that he will reoffend if given the opportunity. Although he may not seek it out, which is what is indicated in the psychosexual, if given the opportunity with a young female, it's highly likely he's a moderate risk that he will reoffend with that child. Factor J, the defendant demonstrates amenability to treatment. The psychosexual indicates that he is intellectually capable of participating meaningfully in treatment. It also indicates that he's above average intelligence. But I would also note for the court that it says his treatment may have been the motivation behind his treatment may have been limited because of his belief that his sexually deviant arousal patterns have not resulted in sexually harmful contact with his victims. So yes, he does engage in treatment, but it also comes with the caveat that he doesn't believe his sexually deviant patterns have actually resulted in harmful contact with his victims. I would also note under that factor that the psychosexual indicates he needs treatment with an Idaho Sex Offender Management Board certified treatment provider. It indicates on page 3 that his true deviant behavior involving children requires additional exploration and assessment. There's other areas that are unknown, and I think that that is in part because he didn't get a psychosexual, or he didn't get a polygraph as part of the psychosexual evaluation. It also indicates on page 3 that he uses sexual activity to cope with stress in his life, and that should be explored, and his impulsivity and poor judgment should be further addressed. And then on page 30 it indicates he experiences deviant arousal when in the presence of young females ages 2 to 4 who are unclothed. So Your Honor, as we go through the factors that weigh in favor of placement in the community, I believe that the majority of those factors vastly weigh against the defendant. 1925-21 subsection 3 talks about the factors that weigh in favor of imprisonment, and I will touch on those now. First factor under A is that there is an undue risk that during the period of suspended sentence or probation, the defendant will commit another crime harmful to another person. As I've already indicated, he has 3 victims. He's a moderate risk to reoffend. This has been a repeated pattern of behavior with the defendant. And I would also note that the victims that he appears to have chosen in the past are all victims who don't have a voice, who can't come forward and report themselves to law enforcement. He targets an age category that makes them particularly vulnerable because they can't defend themselves, they can't speak up, and in many cases they won't even be able to talk. So I would argue that there is an undue risk that during a period of probation the defendant would reoffend again. Under subsection B, a lesser sentence would depreciate the seriousness of the defendant's crime. That factor is clearly met. As I've already indicated, he justifies his actions by claiming that what he did wasn't that bad, that it was just bad thoughts, he stopped himself. But that's not the case. The court heard his bishop testify that the defendant admitted that he touched his child with his penis. And he was found guilty of having the intent to go beyond that, to engage in lewd conduct. And yet, he's been continued to remain in the community because he has never taken full responsibility for everything that he's done. In this case, he didn't come forward and admit what he did and enter into a plea agreement. He was found guilty after a trial. He has not accepted full responsibility for what he did. He had to be found guilty by his peers. Under subsection C, indicates imprisonment will provide appropriate punishment and deterrent to the defendant. I would ask the court, what deterrence to the defendant is there if all that happens is he is placed back into the community? He was found guilty, does not acknowledge the full harm that his conduct has caused. Anything less than prison would play into his rationale that his actions don't harm his victims, and that he feels he was unfairly treated. On page 33 of the psychosexual, it indicates that he said he didn't plan it, he was mixed up, he slipped up one time, and he made a mistake. What a mistake. You pull out your penis when you're attracted to your 18-month-old child, and you place your penis on that child. That is not accepting responsibility for what he did. That is undermining the seriousness of the offense. As far as punishment, a sentence of prison is also appropriate in comparison to the other crimes that the court here in Bingham County has recently sentenced for this same offense, battery with intent to commit a serious felony. In CR 06-21-6676, which is Pedro Ayala, the defendant entered into a plea agreement and was sentenced by the court to a fixed term of 6 years and an indeterminate period of 14 years for a unified sentence of 20 years. And that occurred on July 12th of 23. On June 21st of 23, in CR 06-23-0547, the defendant Carl J. England also entered into a plea agreement after pleading guilty to battery with intent to commit a serious felony, was sentenced to 6 years fixed and an indeterminate portion of 14 years for a unified sentence of 20 years. Those are two cases, though, where the defendants entered into plea agreements, and I would also note some important differences between this case and those. None of the victims in those cases were 18 months old. None of the victims in those cases were anywhere near that age range. In this case, the victim was 18 months old, and for that reason, deserves a harsher sentence. In addition, in both of those cases, the defendants came forward, accepted responsibility, and pled guilty. That did not occur in this case. I think that also weighs in favor of a more harsh punishment. Lastly, imprisonment will provide an appropriate deterrent for other persons in the community. What deterrence is there for the community if pedophiles are able to engage in this behavior and then they're released back into the community? His peers have found him guilty beyond a reasonable doubt, and the punishment should fit the crime. In this case, this is not a drug offense. This is not a property crime. This is not some other status offense. This is a crime with a very real victim, and it's called battery with intent to commit a serious felony for a reason. It's a serious felony, and it should be taken that way. The last factor under E is that the defendant is a multiple offender or a professional criminal. As I've already argued, no, he does not present before the court with prior criminal conviction history. but he does present before the court with other victims. I would also note for the court, before I make my final recommendation, that as the court's considering whether the defendant would be compliant with all of the rules of probation that the court would impose if it considered that as a sentence, almost immediately upon being convicted at trial, the defendant violated the no contact order between him and his victim. He's going to plead guilty to that on April 2nd and has agreed with the state that he will plead guilty to that. But that's also indicative for the court as to his mentality. Immediately upon conviction, he violated the court no contact order. For all of these reasons, Your Honor, I'm asking the court today to hold the defendant accountable, to find that enough is enough, and I would ask that the court impose a sentence of 10 years fixed and 10 years indeterminate, and also that the court require sex offender registration pursuant to Idaho Code 188304. Thank you.
Thanks, Your Honor. A couple of things, Your Honor. For the prosecution to come before the court and mention some factors on 2 cases where someone was convicted of battery with intent to commit lewd conduct without telling us the entire history of the case. I've been doing this for 40 years. I know in plea bargains, they're generally pled down from a more serious offense so that the defendant will not be facing, serious consequences. The particular cases that the prosecution is talking about, we don't. I'm not in a position to address those because I don't know what happened in those cases. I wasn't involved in those cases. I don't know if the state, if this prosecutor was involved in those cases or not. I don't. But I know that frequently in cases like that, I will bet I would just wager without wagering money that which would be illegal. I would wager that in those cases that the factors were much different from this case. In this case, we had a man who was tempted to do something and stopped himself. The jury found that along the way that somehow his penis touched, whether inadvertently or whatever, the child in this case, but he stopped himself. Those other cases, exactly what conduct occurred, I don't know. But I'm not going to assume that those were cases where the defendant, stopped himself before engaging in, particular offensive conduct.
That's right. Let me just interrupt him for the record. The court had those same thoughts as Mr. Jolly was arguing that. I'm not saying it was inappropriate to argue that. Those were the same charges.
Sure.
And the court does strive for consistency. However, the court acknowledges and recognizes that these cases stand on their own, that in this case, Mr. Jones, what he's charged with, what his conduct was, is exactly what you've argued, that he did stop himself from committing more serious crime. So I appreciate Mr. Jolly's argument as for the similar crimes in the community. However, the court also is fully aware that each case has to stand on its own, and the court's very familiar with what Mr. Jones has been both accused of and convicted of in this case. So that's what I'm going to sentence Mr. Jones for what he did, not for what perhaps somebody else did in another case.
Appreciate that, Your Honor, because that's what he's here for. Another thing that I would mention as far as the violation of the no contact order, Mr. Jones was under a misunderstanding that the no contact order would be in effect until his trial. That was what he was thinking. His trial was over. He did have a telephone conference, I think, with one of his kids. And under the terms of the no contact order, he wasn't supposed to do that. He didn't realize that NCO was still in effect after the trial. I spoke with him, about that afterwards, and he understands that now. He didn't understand at the time. He's pleading, guilty to the fact that he did have that conversation. He didn't realize that he was not supposed to do that. So that's what's happening there. And on the psychosexual evaluation, when that was done, Mr. Jones did present himself to take full disclosure polygraph. He had a panic attack. It's the same as happened in the courtroom. He had a panic attack at the time that he was going to take his polygraph, and because of that, the polygrapher that was there said that he wasn't going to go forward, under those circumstances, because he wouldn't get any meaningful information, at that time. So unfortunately, we don't have a full disclosure polygraph, that's true. What we do have, though, is we have Linda Hansen-Bueller's report, and she said that she had, there are things in the testing that she did which are indicators of whether someone is giving her a true story or not. And that's in her report. She says that she was able to verify, the kinds of things that Mr. Jones was talking about from the answers he gave from the testing that was done. She did say that in her report. In her report, she said that I guess overall results were mild. She considered, as far as a risk to reoffend, but she did put him in the moderate category. She indicated that with the type of counseling that Mr. Jones has had, she would recommend go a step further, which is to have a licensed counselor that does a sex offender treatment program. She stated that that would be appropriate in this case. And she stated that she thought one of the things that could be accomplished here, she really wanted to get to what the root of the problem was, for Mr. Jones' urges, as he calls them. She believes there's some kind of childhood trauma that is responsible for that. She'd like a counselor, a sex offender treatment person, to get to the bottom of that. So she did state that. I think the state is going way overboard in stating that basically is looking beyond the facts of this case to try to urge that despite what we see, despite what has happened, despite the positive things that we've seen in Mr. Jones' history, and also the facts of this particular case, that everything should somehow be read as mandating a prison sentence, which I strongly disagree with. The protection of society for deterrence, punishment, and all that. As far as protection of society, this is something that happened 4 years ago. It was something where he came close to doing something more serious and he didn't. He stopped himself from getting counseling since. He did have counseling before then. He was getting counseling before then. That's true. But since that time, this is something that, for whatever reason, he did this with, one of his daughters that was only 18 months old, at the time. She's now like 5. There isn't anybody in the home that is at risk according to what Dr. Hansen-Bueller identifies as the risk age. Why the risk is for that age, I don't know, I couldn't tell you. I've never had a case quite like this, where someone has, is not only in Mr. Jones' case, had that particular, urge to have, to do what he did, and then at the same time feel the need to confess that to his wife, to his bishop, to get counseling, to make it public, that in that sense public, not public to the general public, but to the people around him and to his church. He's trying to address this, and I believe that he has. And for the state to say that 4 years later, because of what he did 4 years ago, that he's currently a danger, to society, I think is misplaced. I would also say that there are plenty of situations where a man is, even if he has had some kind of improper sexual contact, with a child, that they could be in the home supervised by, a person, and it's generally their wife. There are other cases like this that I'm aware of. That when they go home, they're not to be alone, with the child, with young female children. That is, that's not an unusual circumstance or condition. Someone is to be returned to the home. I think it would be appropriate in this case. And again, I turn the court's attention back to the letter of support, from the defendant's daughter that appears on page 3 or 4 of the report. That and also the letter of support from the defendant's wife. The state, had some negative, I'm just calling negative things to say about, the wife's comment and her behavior. But she does know that the children miss their father. The daughter that wrote the letter of support, she knows that the children miss their father. He's not a danger to the children. He is actually a positive influence in their life. Did he do something wrong 4 years ago? Yeah, he did. Is he here to be punished for that? Yes, he is. I suggest, and I understand that it's appropriate to that he register as a sex offender because of the crime. I think that's, of course, required to do that. But as far as an appropriate punishment, I suggest to the court that probation with sex offender treatment and an underlying sentence, as a hammer for probation for whatever length the court believes is appropriate, I think would be appropriate in this case. I would also say that I think I think Your Honor would agree with me. There's a difference between someone's behavior and their risk. If they've never been convicted of crime, and someone's risk once they are convicted of crime for the first time. I think you see that certainly in just starting with juvenile cases. We let the person know that first experience that they have with the criminal justice system is so traumatic that that is an incentive for them never to be in that position again. Same thing with Mr. Jones. Has been incredibly traumatic, for him. And I'm not going to say that's unjust. I think the court's going to say, and I would agree, that he brought it on himself. But it has been a traumatic experience for him. One that is, I would say, a heck of a deterrent, for him. The court's concerned, and the court certainly is concerned about what deterrence, what risk, in the future. I think the deterrence is that this has been an extremely traumatic experience for him. I think the court can be assured that the defendant is, I would say, even less than a moderate risk because of that. He's had this bad experience brought on by himself, and that's something that we ask sometimes, if you learned your lesson, yeah, I would say that we'd have to say that Mr. Jones has. I don't see him as a risk to society. The question is what would be the appropriate sentence, for something like this. He has been in jail since the jury came back with a guilty verdict. I would suggest that the court consider that, as part of the sentence, that he's be given credit for time served, put on probation, have a sentence hanging over his head if he does violate probation. I'm confident that he will not. I've been dealing with him the entire time, and from what I've seen, that I can't see that he's going to be giving the court or anybody any trouble in the future. Thank you.
Thank you, Mr. Brown. Mr. Jones, for any sentence in this matter, I'll give you a chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you wish to address the court, I give you that opportunity. And if you are going to address the court, if you could please stand. So would you like to do so? Let me just caution you, if you're going to read something which is very appropriate, people read a little faster than they normally speak, and the court reporter will need to write everything down, so just try and read a little slower than you normally might.
Okay.
Go ahead, sir.
Your Honor, what I did 4 years ago was wrong. It's wrong and immoral. I've caused significant pain. Significant pain and confusion to my family. I'm trying to do all I can to accept full responsibility and to ensure there is no risk to anyone ever again. I believe my actions over the past 4 years demonstrate my commitment to change in at least 6 ways. Number 1, I stopped myself right after the impulse and quickly put my daughter down, pulled up my shorts, and left the room. 2, I immediately felt horrible and told my wife and Bishop about what I had done. In other words, the reason I'm here is because of me, and I want to make it right. 3, I voluntarily sought counseling and have been meeting with my counselor weekly for almost 4 years. During this time, I developed skills and knowledge that help me identify triggers that could lead to risky behavior. I also learned how to avoid them and appropriately deal with them when they came. I now feel that with the skills and things I learned that I can avoid triggers and be at no risk to anybody in the future. I've consulted regularly with my wife and we established a safety plan that we follow to ensure the safety of our children. 5, I've gone to church every week and consulted with our bishop regularly. I've also been going to church in jail and have been part of a daily Bible study and fellowship meetings. Additionally, I've participated in a 12-step addiction recovery program and counseling sessions. I receive constant strength through daily personal scripture study, prayer, and faith in God. Number 6, the past 4 years, I have not repeated the offense and have worked hard to adjust my thoughts and actions so that I can be a strength and blessing to my family and community. I think it's significant to note that a forensic analysis was completed on my daughters a year ago and they found no concern with me being in the home. Since my youth, I have always tried to be a good person. I've always attended church. I've never used any drugs or alcohol. I've never looked at pornography. I became an Eagle Scout. I've always done well in school. I volunteered in numerous service organizations in college and served a 2-year mission for my church. I've tried to be a good husband and father. I have no prior criminal record and I don't even use swear words. It is perhaps because of this lifestyle that I was very embarrassed by my immoral urges that I had. Additionally, sometimes I go many years without any urges. While I tried to be open and honest with my concerns due to the embarrassment I felt and the rare frequency of the urges, I did not do what was necessary to resolve the problem. I'm done with being embarrassed and I'm ready to do whatever it takes to make sure there's never any risk ever again. These last couple of months in jail have truly been a humbling experience for me. I've learned a lot about myself, about what's truly important in life, and about the changes I need to make. I've also heard a lot about what prison is like. The environment of jail and prison are extremely contrary to my nature. For instance, I'm not a vulgar or an aggressive person, 2 characteristics that are pervasive within these institutions. I'm concerned that the fear and anxiety I've felt and am likely to experience will inhibit the growth I hope to achieve. If granted probation, I have employment set up and ready for me to provide for my family financially. It is impossible for me to describe the agony I've felt because of my actions and their consequences. To say that I'm sorry is an understatement. I loved my family with all my heart and would do anything for them. My wife and I love each other deeply. We support each other and we need each other. The same is true of my 6 children. I ask for the chance to prove my commitment to change and to provide for and protect my family. I will continue to see a counselor. I'll abide by any conditions set forth with probation. I look forward to participating in any treatment program assigned by the court. I ask for mercy and the chance to show that I'm willing to do everything in my power to make sure I am not at risk to anyone ever again. Thank you, Your Honor, for your time and consideration.
Thank you. Be seated. Go ahead. Are you satisfied with the representation of your attorney?
Yes.
Brown, is there any legal reason why I should not sentence the defendant today?
No, Your Honor.
Mr. Jones, based upon the jury's verdict of guilty, it's judgment of this court that you are guilty of the crime of battery with the intent to commit a serious felony. I have carefully reviewed the record in this case. I was there at the jury trial. I heard the evidence. I listened to the argument of your attorney, to the argument of the state, As indicated, I read through the letters that were attached to the pre-sentence investigation report and would note they were numerous, all complimentary, and I think helped the court to make an informed decision about what kind of a person that you are. I have listened carefully to your statement. I've read through the psychosexual evaluation, and the court has the obligation of reviewing what to do in light of the objectives of criminal sentencing adopted by the Idaho Supreme Court. The state referred to many of those in their argument. It basically breaks down to the 4 factors of criminal sentencing: that of protection of society, deterrence, rehabilitation, and punishment. All of which the court is required to take into account, and all of which are important in this case. And frankly, your attorney has argued well on your behalf and talked about the mitigating factors, has talked about the family that you've supported, the fact that you took some accountability, you talked to your wife, you spoke with your ecclesiastical leader, that you came up with a safety plan. You yourself list those things, same things in mitigation, that you've attempted to correct the wrong. The state has argued, as often happens in these types of cases, for the protection of society and for deterrence. The court is greatly concerned about rehabilitation, and then of course the 4th factor, punishment or retribution for wrongdoing. In this case, the facts as disclosed and as found guilty by a jury of your peers was that there was touching of an inappropriate nature between you and your 1.5-year-old daughter, where you had her while changing, while she was changing her clothing, and that you took out your penis and touched her. Now, I will say that this is not a lewd conduct case, and I give you credit for that. You did stop. It could have been worse, and the court sees this case as not as severe as a lewd conduct case where there is penetration, multiple events with the same victim. So like I said, and I think it's important to note that the court has the obligation of sentencing for this crime, and the court has already made comments on that. I do think you're remorseful. It's been difficult in this case because of the age of the victims, they don't remember it. They don't remember what happened. And as has been argued by your attorney, they're more traumatized by what's going on now than actually what happened. And the court's mindful of that. But the state has argued and argued effectively and efficiently, and in fact is referred to in the psychosexual evaluation, that those victims are the most vulnerable. They can't stop you. They can't tell somebody this was wrong. They can't go and report it. They can't do all of those things that society says kids can do to protect themselves. Also, the court's mindful of the fact that this isn't the first time this happened, that similar type actions have happened. I took some notes as the attorneys were arguing. There's been a lot of discussion about how you have these improper urges. But the urges aren't the legal problem. It's the acting on them that's the legal problem. That's the issue. If you have the urges and you don't act upon them, I'm not saying that that's not a problem. People shouldn't address that as an issue, because they absolutely should. However, that's not what you're here for. You're not here for sentencing because you have urges. You're here for sentencing because you acted on those urges. You acted on them, and for whatever reason, you victimized your daughter at a time when she could not protect herself, could not speak to it. And now, like I said, it's put her in a position where, sadly, I've dealt with many of these crimes over the years, both as a defense attorney, as a judge, and as a prosecutor, and the impact of the victim on the victim continues. The sad thing is that the victims are going to need counseling to help deal with this for potentially the rest of their life, because of the fact that they're going to feel guilty for what happens to you. That's the nature of the crime. Even though they don't remember what happened, it will still carry with them for the rest of their life. I read the psychosexual evaluation carefully, noted that there was no polygraph examination. Whether that was a conscious choice or not, the court doesn't have an opinion on that, other than I don't have that. Would note that the court was mindful of the panic attack you had at the end of trial, and the fact that that happened as well. But the fact of the matter is I don't have a full disclosure polygraph to consider. There was discussion, and you had disclosed about the prior incidents, both with the older daughter as well as in another country. And I noted, for example, the findings of Dr. Hatzenbuehler. The state referred to them as well. I wanted to look at page 33 of the psychosexual evaluation. It's on page 50 of the entire packet, where it says the report he's been in treatment for sex offending amidst sexual arousal of children. He admits committing a sex offense. However, when responding to the psychosexual testing, he claimed he didn't plan it, he was mixed up, he slipped one time, and he made a mistake. These attitudes should be addressed in treatment, as they keep him from accepting full responsibility for his behavior. On the next page, talks about the safety plan, and once again, this cuts, I agree with the state, it cuts both ways. It says the safety plan developed for him and with his family should be reviewed to assure it is comprehensive. He appears to have offended despite the safety plan that was developed by him and his wife. He should not be allowed to be in the presence of underage females without supervision. I make this recommendation both to assure the safety of underage females, but also to ensure that he is not wrongly accused of future offenses. His history places him at risk for such accusations. There's been discussion about the no contact order. There's been discussion about the sex offender registry, and the court will deal with both of those issues. One of the letters struck me, a letter from Mr. Hall, Brian Hall, where he talked about the fact that I've learned, this is the second last paragraph, I've learned that our justice system can work for the good of everyone if an equal amount of justice and compassion are involved. Eric is a good man who has made a mistake. However, over the course of the past 3 years, a lot of hard work on Eric's part and some time spent in jail, he has learned from his mistake. And I wrote that there has to be an equal amount of justice and compassion. Your attorney has argued for compassion. The state has argued for justice. Both of them have done what their responsibilities are. The court appreciates both of their insights. But ultimately, it's up to the court to determine in this case. And as indicated, the court will consider the criteria in Auto Code 1925-21. I'm not going to review it as the state has already done so. But the court did review Auto Code 1925-21 relative to the question whether I should place you on probation or confine you to prison. I've also considered the criteria of protection of society, deterrence, rehabilitation, and punishment. Based on those factors, can be the judgment of this court. It should be sentenced to custody of the Ohio Department of Corrections as follows: for a total unified sentence of 20 years, with a minimum sentence of 2 years, followed by an interim sentence of 18 years. I'm going to order a fine in this case of $1,000, standard court costs, payments of the Victims Relief Fund. I didn't see any request for restitution. However, the court will continue to allow that to be supplemented if and when there are other counseling expenses. I'm going to order that you register as a sex offender pursuant to Idaho Code 188307. I have considered a retained jurisdiction or a rider. The court is not going to authorize that. I feel that doing anything other than the sentence I have given will minimize the seriousness of the crime and will not have the proper deterrent effect. So I'll give you credit for the times you've served up to this point, but we'll order that you be taken to the custody of the Department of Corrections for imposition of the sentence. As to the no contact order, the court is going to vacate the no contact order at this point, as any contact you will have will be supervised and monitored by the Department of Corrections, and we'll leave that up to the parole officer when and if you are paroled in this case to do an assessment, as the kids' ages will continue to change, and I know that they will require a complete polygraph prior to any release. Let me advise you of the right to appeal. You have a Supreme Court from this judgment of conviction. You have a right to represent a binding attorney in this appeal. You cannot afford an attorney. A term will be appointed through public expense. However, you only have 42 days from today's date to file that. You also have the right to seek relief under Idaho Criminal Rule 35 if you feel the sentence was illegal or unduly harsh. You have 120 days for that. You also have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the date your right to appeal expires. If you have any questions about those things, please consult with Mr. Browning. The court's also going to require that you submit a DNA sample and a right thumbprint consistent with Idaho Code. Any questions about the sentence in this case, Mr. Browning?
No, Your Honor.
Mr. Jolly?
No, Your Honor.
All right, I'm going to order you back to the Bingham County Sheriff for execution of the sentence, and we'll be in recess on this matter. Of course, it takes you.
Please rise.